It's time for Declare Your Independence with Ernest Hancock.
Believe me when I say we have a difficult time ahead of us. But if we are to be prepared for it, we must first shed our fear of it. I stand here without fear because I remember that I am here not because of the path that lies before me, but because of the path that lies behind me. I remember that for 100 years we have fought these machines. And after a century of war, I remember that which matters most. We are still here! Tonight, let us make them remember we are not afraid!
No fear, no fear, no fear, no fear here on Declare Your Independence with me, Ernest Hancock, here in Phoenix, Arizona, from the BEA beautiful studios of Freedoms with an S, freedomsphoenix.com. Let me tell you what we're going to do in the first hour. Dylan Reeves is an attorney from Alabama, and he has something to say about the censorship or non-censorship of violent video games and the Supreme Court decision that came down. We talked about this. Well, you know, we even referenced it in the last couple of days as we talked to filmmakers that made this one movie called This Movie Is Not Yet Rated. And the point that they were making is that, you know, who makes these decisions? Based on what? And their argument was that it was economics. You know, we make money on violence, you know, and I guess sex doesn't sell as much. You'd think it would. But my question is that we're going to get into what should be censored, if anything, and when it is, based on what criteria. Now, here's someone that has an opinion on whether we should be censoring violent video games, or at least making the manufacturers of such things liable for some kind of a tort against polluting the minds of the young. And I'm going, okay, what's the criteria? And does it apply to other types of visual stimuli? Well, we'll get to that in a second. I tell you, in the second hour, we're going to be talking about, you know, lots of stuff going on. Tomorrow, Jordan Page comes in tonight. He's going to be performing in Quartzsite tomorrow. We're going out there to cover that live. And you guys, we're going to be working out now. Should we do it through Skype and give you some live coverage, audio and visual that way? Should we be using our quick account so you can get, you know, 1-2 minute updates real quick of what's going on there? Should I just be doing the radio show and you streaming it? Do we go ahead and have it edited and put up later that evening? I mean, all kinds of stuff's going on. But the coverage will start tonight because here at my home, we're hosting a party with Jordan Page while Stuart Rhodes and Oath Keepers and so on out there having a good old time. So we'll go ahead and give you a live and updated coverage, everything going on. Just keep checking on Freedoms with an S, freedomsphoenix.com, and you'll see all the links and see I'll get it all hooked up for you guys. Now, Dylan, I got you there?
You do.
Now, Dylan, you got some street cred here. I mean, you're official. You know, what is your position here? You were appointed to the board of editors of the Alabama Lawyer. That's the official periodical of the Alabama State Bar. So I would imagine that you're semi in good stead with your group there. They're not excommunicating you yet, making you an editor. So this, I would imagine, is an opinion that not just you hold, but others. And I want to be clear on what the opinion is. When you have, the case was in California, Schwarzenegger signs it in, it goes to the Supreme Court, and they ruled what about what? Go ahead and explain that to us.
The Supreme Court, although they had a very solid majority in favor of striking down the California law, the Supreme Court said that the definition used by the state of California was too broad and overreaching of what is a violent video game. It's one of our fundamental principles of free speech here that we can't have overbroad and far-reaching laws. That a state has to show a compelling interest in restricting our First Amendment rights. And those have to be narrowly tailored. And what that means basically is if the legislature has another means to achieve what they're setting out to do, they need to use that less restrictive means. And the Supreme Court said the California law did not do so.
Okay, how could a law do so? I mean, this, okay, let me give you some background. You understand where I'm coming from. The reason I was so interested in this decision was John Stewart did a really good job of it, that really came down to this. Well, if it was sexual content, regulate away, okay? If you had something, Scalia comes out and he says, if it was more, you had a nip slip on one of the characters, well, then all of a sudden, you have a little bit more leeway. And I'm wondering if we're going to use some kind of criteria to have the government censor material for fill-in-the-blank reason. And it's always for the children, it's for whatever. They're going to use some kind of definition. And I'm going, all right, one, what kind of definition do you use? How do you do, like you're saying, we can't have it too broadly defined. And I'm always wondering how it is that we have violent movies and television and blood splattering onto the lens and all this other stuff and violent video games. But, that's okay. But if we have anything pleasurable, sexual content, that's not. And I'm going, whether you agree either way which one should be, I'm just wondering, what is the criteria that we use to determine what is damaging to a young mind?
Sure. Well, first of all, let's be clear. Pornography is its own type of an exception to free speech. It's obscenity. It appeals to the prurient interest.
Why? You'll say it's different. I'm going, okay, who decided it was different, and how is that difference delineated?
Sure. That's just something that's evolved with our common law here in the United States, and that gets into it briefly in the Clarence Thomas dissent in the Brown versus Eme opinion, but it's just one of those traditional categories. Why? It's tradition. That's why it's been singled out and given a different test than violence has. Violence has always been protected in that most of the time violence is just seen as objectionable and offensive. Now, we have an exception.
So what's pornography seen as?
Pornography
really objectionable and really offensive?
According to our common law.
Okay, and you're talking common law as precedent set by the Supreme Court? Is that what you mean?
Yes, the historical growth of our law coming over from the common law of England.
Wow, they were dealing with pornography and violence? I mean, you got to help me out here. I'm really trying to understand this, because this has been a regular problem with me for a lot. I have 4 children. They're 21 to 25. They, 2 boys, 2 girls. So I went through this. I mean, they're wanting to watch horror film. Not in my house, man. You go whatever, and you think you can sneak in and get and whatever. But why pollute your mind? I'd rather you be watching, naked bodies entwined and watching naked bodies sliced up with a machete. Okay, it just seemed to me that there was like a social engineering thing going on. And when the Supreme Court came out that, well, if it was sexual in context, well, then you could regulate it. But since it's violence, it's okay. And I'm like, not that I'm advocating for any kind of censorship. I'm just that they would even mention that. And I'm going, what kind of sick mind is it that has common law that violence is okay, but sex isn't? I want you to help me go back, because obviously you studied this to have an opinion on this, to write on this, to interject yourself in this. I'm just wanting to try and understand where that basis came from, how it's evolved, and where we're going now, and is that always the standard? Help me out, man. I'm trying to understand this.
Sure, and I think it may be one of the great double standards of law.
Great.
Of what is objectionable, and
how do they base that? How do they determine what is objectionable? Is there some study? Is it whether some censor they got or congressman, whether he pitches a tent watching what? I mean, what?
Sure. Well, we have.
Well, go ahead and think about that. We're hitting break. I apologize. Now, when we come back, we're going to go ahead and hopefully we can get Dylan Reeves, an attorney from Alabama, involved in this case. He's going to go ahead and help us understand, because I don't even see how we can go to the next step and discuss what other alternatives there are until we even know what the heck we're talking about. How do you go to another alternative if you don't even know what criteria you're using to decide what alternatives you need to use to accomplish what for the brains of the children?